We're returning to 18B 1541-1, State of Georgia versus Tiffany Nicole Moss. The defendant's present along with standby counsel. State's counsel is present as well. I am informed that we have a verdict. Please bring our jury. Yes, sir. You can be seated. Thank you very much. Welcome back, ladies and gentlemen. I'm informed you have a verdict. Is that correct?
Correct.
Is it unanimous?
Yes, it is, Your Honor.
Has it been signed by your foreperson?
It has.
Please give it to the bailiff. This is the jury's verdict in case 18B 1541-1, State of Georgia versus Tiffany Nicole Moss. Count 1, findings of jury as to alleged statutory aggravating circumstances. We, the jury, find beyond a reasonable doubt that the offense of murder as alleged in count 1 was outrageously or wantonly vile, horrible, or inhuman in that it involved torture of the victim before death. We, the jury, find beyond a reasonable doubt that the offense of murder as alleged in count 1 was outrageously or wantonly vile, horrible, or inhuman in that it involved depravity of mind of the defendant. Signed and dated by the foreperson. Verdict as to penalty, count 1, murder. We, the jury, recommend and fix the penalty as death. Signed and dated by the foreperson. Please give it to counsel for their review as to form, sir. Any exceptions to the form of the verdict by the state?
None from the state as to form or substance.
Any exceptions to the form of the verdict by the defense?
No, Your Honor.
Ladies and gentlemen, under these circumstances, it's necessary that the court conduct a poll of the jury. It simply means that I have a series of questions to ask you each individually. We'll begin with juror. By you?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
Thank you, ma'am. Juror. Ma'am, you've heard the verdict as I announced it. Was that your verdict in the jury room?
Yes, it was, Your Honor.
Was it freely and voluntarily made by you?
Yes, it was, Your Honor.
Is it still your verdict?
Yes, it is, Your Honor.
Thank you. Juror. Ma'am, you've heard the verdict as I announced it here in the courtroom. Was that your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
Thank you very much. Ma'am, you've heard the verdict as I announced it. Was that your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you?
Yes, Your Honor.
Is it still your verdict?
Yes.
Sir, you've heard the verdict as I announced it here in the courtroom. Was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
Juror. Sir, you've heard the verdict as I announced it. Was that your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
Juror. You've heard the verdict as I announced it here in the courtroom. Was that your verdict in the jury room?
Yes, sir. Yes, Your Honor.
Was it freely and voluntarily made by you?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
Sir, you've heard the verdict as I announced it. Was that your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
Heard the verdict as I announced it. Was that your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
Sir, you've heard the verdict as I announced it. Was that your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
Ma'am, you've heard the verdict as I announced it. Was that your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
Sir, you've heard the verdict as I announced it. Was that your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you?
Yes, Your Honor.
Is it still your verdict?
Yes, Your Honor.
That whole of the jury. Any additional need to retain the services of this jury panel any further for the state?
No, Your Honor, the jury can be excused, but, and first of all, I want to thank the jury for their service throughout this trial, but there are going to be issues regarding the press and that it's entirely voluntary with them that may better come from the court.
I will instruct them on that, yes. Any additional need for the services of this jury panel any further? Ms. Moss?
No, sir, Your Honor.
Ladies and gentlemen, I want to thank you all very much for your service. Obviously, getting the news that you had jury service, particularly on a case that was expected to last as long as this one might have, was probably not the most welcome news that you received that particular week. But I find that jurors that have actually had the opportunity to sit in on a case and serve understand the importance of jury service and the important role that jurors play in our criminal justice system, perhaps more than you might otherwise have appreciated it before. So I want to thank you all very much for your service in this case. I've repeatedly told you throughout this process that you should not discuss this case with anyone or allow anyone else to discuss the case with you or in your presence or hearing. I now relieve you of that obligation. You're free to speak with whoever it is that you might like to about the case. Sometimes the attorneys or other participants in the case like to talk with jurors because they'd like to have your insights into what it is that may have gone on during the trial. If the attorneys talk with you, it's not for the purpose of second-guessing any decisions that you might make, but like any professional, perhaps your insights would help them when they present cases in the future. Because of the level of press attention, you might also get approached by members of the press or others that are curious about your impressions about the case. You're certainly welcome to speak with all those people if you want to, but you're under absolutely no obligation to speak with any of them if you don't want to. And I'm sure if you explain to them that you'd prefer not to discuss the case, they won't bother you any further. Once again, ladies and gentlemen, I want to thank you all very much for your service in this case, and you are excused. You can go out with Arbellis. Our jury's been excused. We'll proceed immediately to sentencing. Is there anything that the state would like to say before I impose sentence on the defendant?
No, Your Honor, the jury's spoken, and the state has nothing further to add.
Ms. Moss, if you'd stand up for me, please, ma'am. Is there anything that you'd like to say before I impose sentence, ma'am?
No, sir, Your Honor.
Ma'am, with respect to count one, the jury has found you guilty of murder and other counts contained in the indictment against you. They have considered the circumstances surrounding that murder and found that aggravating circumstances exist. With respect to count one, ma'am, I impose the sentence of death. Counts 2 and 3 are vacated by operation of law. They're felony murder charges. Counts 4 and 5, the cruelty charges, of course, merge. With respect to count 6, I impose a 20-year sentence to be served in confinement, ma'am. With respect to things that you should also be considering, ma'am, you should understand that the law requires that the date of execution be scheduled by the court at this time. OCGA section 171034 requires that the court set the date of execution not less than 20 days nor more than 60 days from today's date, and there's a 7-day window within which the execution is to take place. I fix the date of your execution, ma'am, as the 7-day interval between noon on June the 7th, 2019 and noon on June the 14th, 2019. You should also understand, ma'am, that there's an automatic review process of a conviction in a case like this. A defendant may elect to proceed either by motion for new trial or direct appeal, or may allow the case to be presented directly to the Supreme Court for review. OCGA section 171035 requires an automatic review of a death sentence, and that will be conducted whether you file either one of those motions. But understand, ma'am, if you'd like to file either a motion for new trial or a notice of appeal, you have 30 days from today's date within which to do so. Ma'am, you've obviously chosen not to have representation throughout this portion of this case, but obviously you also have the right to have an attorney represent you in connection with any appeal that might be taking place as well. Thus far, you've rejected all efforts to give you legal representation, but I want you to know that you do have the opportunity to ask this court to appoint counsel to assist you with whatever appeal it is that might be necessary. Also, the Capital Defender's Office may have some resources that might be brought into bear to pursue whatever appellate needs it is that might exist in connection with this case. But I want you to understand that if you ask for appointed counsel and you qualify, ma'am, I would certainly consider appointing counsel to represent you in connection with whatever appeal it is that might be necessary. I want to also let you know, ma'am, that there is a process that you could collaterally use to attack something connected with this case. It's called habeas corpus. Your standby counsel can give you more detailed information about exactly what habeas corpus is and how you might pursue it if you're interested in doing so. But you do need to understand, ma'am, that there's a 4-year time limit within which you have to pursue habeas corpus relief. That time limit begins now. Are you the holder of any weapons carry licenses here in the state of Georgia or anywhere else, ma'am? I will ask the state to retain the evidence that was presented through the course of our proceedings as an officer of the court and retain it safe pending any appeal that might be necessary. Ma'am, do you understand the sentence that I've imposed in this case?
Yes, sir, Your Honor.
All right, ma'am. That concludes our proceedings. You may go with the deputies. Thank you. That concludes our proceedings.